our webinar on DSARs without losing a week. We put a week on there, but it could have been a month.
It could be, could be
a day, could be 3 months, depending upon the nature of the DSAR itself. But essentially, you'll get the message, which is that we want to try and sort of talk you through how you can handle these in a way which is not going to take over either your life or the organisation's life whilst you're in it. So I'm Matthew Cole. I'm a partner in the employment and data protection team here, and I'm joined today by Maria, who's an associate in the team. And we were just briefly talking beforehand about, and I should have known this, how long Maria's been with us, which is 7 years, and during that time, how many DSARs she has dealt with, and we got to a few hundred.
Yeah.
So you're in good, experienced hands today. So what we're going to be doing? Well, we're going to start off. We've got an hour. We might go on a bit longer, but we fully understand for those of you who want to leave after an hour, because of an hour of a DSAR is enough for everyone, for anyone. But we've got an hour. We may go over. We're going to be talking about just where we are with DSARs in terms of the law. We won't dwell on that, because actually what we really want to focus on are the practical ways of dealing with DSARs, and that's particularly where Maria is going to come in. And then we'll just finish off by with some conclusions and some shameless plugs for our DSAR services. Mm-hmm. So those are sort of three areas we're going to cover. You may have questions. If you want to put your questions in the chat, then please feel free to do so, and we'll try and deal with them as we go along. If there are questions which are better off for us to respond to at the end, then we'll do so. So we will try and get to all questions, I promise, but do feel free to sort of stick questions in the chat. So what are we looking at when we're talking about DSARs? Well, as you will all know, we're talking about subject access requests, and we know that subject access requests are becoming increasingly common and increasingly burdensome. There's been a year-on-year increase. Now, we don't actually know how many DSARs are floating around, because the nature of DSARs is very informal in many cases. But what we do know is that the ICO reports on the number of complaints they receive from data subjects. Last year, they were recording about 40,000 complaints, and about 40% of that 40,000 related to DSARs. Mm. They are forecasting that over the next year, the number of complaints will actually increase to over 50,000. So we can assume that the number of DSARs is increasing, and that the number of disputes relating to DSARs is also increasing. And I think, Maria, it would be our experience, wouldn't it, that there is a rise in DSARs. Yeah, absolutely. And we don't think that's going to change. So we see year-on-year increases. We also see them being used tactically. I've put up there as an example how they're used in employment disputes. But Maria, if you just go to the next slide for a minute, we can probably deal with that here. We actually see what the primary motivations for DSARs are. This is a compounding of a number of surveys. But effectively, you'll see that the majority of DSARs relate to some form of complaint or litigation, and in particular employment litigation, which is where most DSARs now are what they're mostly motivated by. And again, I think that would be our experience. Maria and I sit in a joint employment data protection team, so we see that confluence of the two areas play out. So we tend to see DSARs very much coming through with a litigation bent in mind. And you can see why. They're very easy for individuals to make. They're free. They don't take much. We're getting a few people just coming through that saying they can't hear anything. I think Steve, who is our administrator, will try and sort that in the background. I am going to assume that because we've only had two people who can't hear anything, other people can, and we will continue. But occasionally it can be it can be a browser issue. But I'm gonna carry on talking, and I'm gonna leave Steve to try to fix the sound issues that we appear to be
and just
having.
Just to say, I think we are recording the session, so if you can't hear anything,
we'll send it to you.
Yeah, absolutely.
And thank you for those who have confirmed they can hear. So I'll continue. So anyway, what we see is actually the majority of SARs are coming through in a situation of conflict or potential conflicts. And again, that's important to remember in terms of context, because of course it means that they are being examined more carefully and less benignly than we would like, and also that they are potentially going to be examined at another date. We'll go back to the previous slide, Maria. Thank you. And we'll just go through some of the other trends. Hybrid working undoubtedly has led to more complexity around SARs. The number of channels being used, the number of informal channels being used amongst employees is very high, and that adds a degree of complexity to a SAR. And we'll be coming back to the dreaded word WhatsApp at some point a bit later, because WhatsApp is the bane of our lives when we're looking at subject access requests. We'll come back to that. We've also got to get to grips with AI and AI generated content. It's a real problem. We've written about it and we've talked about it before, but because of the obligation on organizations to be able to explain the rationale for their processing and the decisions being taken, AI disclosure in a subject access request is a real problem. We've seen this at European court level, and Austrian referral through to the European Court of Justice in the Dun & Bradstreet case said that there is a real obligation on organisations to make sure that they are explaining the logic behind the decisions that AI are taking when there is a subject access request. So we've got to be very conscious of that. And again, the last point I'll just pick up on here is less tolerance from courts and regulators. There is a sense that organisations should be able to deal with SARs.
Yeah.
That they are set up, and we'll come back to this, won't we, Maria? Talking about the systems we have in place, that you are expected as an organisation to be able to respond to a SAR and to be able to respond within the time frames set out.
Sorry, just on the AI point as well, we are also seeing an increasing number of clients and organisations receiving subject access requests that have been written by AI. You can spot, well, I can certainly spot them from a mile off just by how they look, but more and more people are using AI to generate their request and then also to raise complaints once they've received the data. And so it can feel like a never-ending cycle of communication with yourself and the data subject.
Yeah, I think that's a good point. I suspect also tools being used to analyse the data that's generated. But on the other side of the fence, there are some good tools now coming through to actually help with responding to a subject access request. We'll be coming back to tools at some point. We can go to the next slide. So we have a complex picture, and one which is now sort of acknowledged to be costly for organisations. Again, a Gartner survey, so from a good reputable source, cost of manually fulfilling a single DSAR is at about £1,200. I don't know how they get to £1,200, but in effect, there is a cost involved in these things. And there is a greater time cost. Again, various surveys, lies, damn lies and statistics, but somewhere between 13 and 53 hours of time per request. And how many requests can you expect? Well, again, the Gartner came up with this figure that for every 1 million identities you hold, so every 1 million data subjects an organisation has got, and obviously many of us will not have 1 million data subjects, but you'd be surprised it doesn't take too much to get up to a very significant number. Yeah. But 650 for every million. And I did actually go down through the figures, shows how bad my maths is now. What does that mean when we're looking at it? It means 6.5 per 10,000 So you can see how most organisations are at some point going to be having a SAR in some form or another if they've got a significant database.
Yeah. And people talk, don't they? If you've got an employee who's disgruntled because they're going through a redundancy or dismissal process, and they've maybe got a pool of colleagues in the same position, they will talk to each other and say, I've submitted to DSAR, why don't you do the same? So it is that easy, and you can quite easily end up where you've got, I don't know, DSARs that are snowballing. So people talk.
People talk, and they're so easy to make.
Yeah.
So again, we have a picture where these things are not cheap.
Just had a question come through about WhatsApp. It isn't able to answer. So somebody's asked, if there is no secure comms channel provided by the organisation, then people resort to using WhatsApp. But isn't it also true that even when there is a secure comms channel provided, people still resort to use WhatsApp? And what's the best way to mitigate this? Yeah,
it's a really good point, and you can sort of sense the frustration coming through in the question about WhatsApp.
Yeah.
The big problem with WhatsApp is that it's a very attractive, secure, easy way to communicate, but that there is a general expectation that employees will effectively use their own accounts. So a manager just sets up, well, let's do a WhatsApp group to make sure we know who's going to be able to work and cover particular shifts, for example. And everyone sets them up on their private WhatsApp app. Or you have a senior exec WhatsApp group just to share intelligence and information. All these things are so easy to set up. And that's really the problem. And then there is an issue, and it's been debated in court at a high level, the extent to which a WhatsApp data, a personal data, a data belonging to the data controller or data belonging to the individual manager. So to what extent do they need to be disclosed? I think there's a couple of things you can do. If you know that WhatsApp is out there and is being used, how do you mitigate its use? Well, first of all, having another channel, so having Teams or Slack or whatever else, is really useful. Having a policy that says for all work communications you should be using that is also important, and having something that says please do not use WhatsApp again is important. So all of those things will help you to mitigate that. But certainly when we're looking at what channels we have to assess when we're doing our subject access requests, then we've got to consider whether WhatsApp is or is not in scope. And again, Maria, you'll know better than me, but I think it's fair to say that often when we get the subject access requests in, WhatsApp is specifically mentioned.
It is, yeah.
Because individuals know that there is likely to be some salation. Yeah, exactly. And unguarded comments in particular. So there we are.
Yeah.
So we'll come back to that kind of issue a bit more, but mitigate it by policy. Right, just what are we seeing in enforcement trends? As I said, the ICO is inundated with complaints about DSARs. What tends to happen with the ICO is they're not after fining people, they're not after putting people out of business. What they really want to do is to have a dialogue and only move to more informal enforcement when they absolutely have to. There's an example there, Bristol City Council, who were well behind on their DSARs by the middle of this year. They had about 200 outstanding DSARs which were outside of timescale, and the ICO worked with them for quite some time to try to encourage them to get the backlog down. When they didn't, they issued an enforcement notice. They gave them some time limits to hit, and they gave them certain other obligations to put in place with regards to putting in place policy and structure to be able to answer DSARs in time. And again, we'll come back to the importance of policy and structure later. Most of the enforcement trends are around the public sector, but we are seeing some specific sectors just starting to be targeted. Care, education, financial services, all sectors where there is a lot of sensitive data and a lot of data are all starting to come in scope at the ICO. And what we are seeing at the ICO is they've just issued a white paper, a consultation paper about their future enforcement strategy. They're going to be moving towards looking at trends rather than looking at individual organisations. And those are three sectors which are very much in scope. We do see enforcement via the employment tribunals. If there's an employment dispute, if a SAR is not responded to in the correct way, then it's not uncommon to see the claimant, when the claim comes through, asserting that failure to respond properly to a SAR in some way or another, either as victimisation or in terms of withholding of information. So we get some of that satellite litigation involving SARs. And we also see other litigation. It is possible to go to court and assert that your subject access rights have been breached, and that's a standalone claim in the courts. It can be a very expensive claim to make because you have to make it in the High Court. But increasingly, what we're seeing is that the judges within the High Court will move it from there to the Small Claims Court, because actually there's £10,000 or less of compensation at stake. So it should be moved to the Small Claims Court. And as the judges become more used to dealing with SARs and disputes over SARs, that's what we will see more and more of, I think. And that starts to bring them in scope for individuals in a way which we haven't so far seen. So we're expecting more litigation. Right, I'm going to go very quickly through this, but it's the purpose of this slide, and certainly the points at 1 and 2, are to say that SARs are to be taken extremely seriously. Access to information is regarded as a fundamental right. And that's how the courts interpret them, and that's how the ICO interprets them. So it's a fundamental right, and it will continue to be serious. Whilst it can seem very frivolous to actually issue a SAR, very easy to do, and it can be done for all sorts of ulterior motives, there is a fundamental right to do so, and we've got to see enforcement through that lens. We know that we're looking at the Data Protection Act, UK GDPR and the Data Protection Act, but we are still informed by EU cases. So I mentioned the Dun & Bradstreet Austria case earlier. Cases like that still play heavily in the UK courts, but the UK courts are increasingly looking at this. We'll come back to talk about the Ashley and the HMRC case a bit later, but it's a judgment involving Mike Ashley of Sports Direct fame, where he sought information from HMRC, and the court in that case gave a very wide interpretation to the right of access to data. And finally, a change coming through next year, which is going to affect this as well, the Data Use and Access Act 2025. There are certain things in it which I think are very positive, aren't they, Maria, in terms of how SARs are to be interpreted around proportionality?
Yes, yeah, and definitely we've seen kind of what we already know about DSARs and having to respond to them in a reasonable and proportionate manner being codified. One thing to note about the Data Use and Access Act is that organisations will be required to put in place a complaints handling process, and that information must be made available through your website. So if somebody has a complaint about the way their personal data is being handled and they want to make a DSAR, that information should be readily available to them through your website. So it's just something to bear in mind over the next year.
But very significant, I think, in this context, isn't it? I think it comes in is July next year. And effectively what we're going to have is, it's going to be a case of, right, okay, we've dealt with the DSAR. The individual subject comes back and says you haven't dealt with it properly. You've then got to go through your complaints handling process.
Yeah.
They can then go off to the ICO. And what that means is effectively they will have a double complaint. They will no doubt complain that you have not dealt properly with their subject access requests, and then they will say that you haven't dealt properly with their complaint about your failure to do with their subject access. That's how I think it's going to work. We will be talking more about that complaints process in some future seminars, because I think it's going to be a very significant obligation on organisations.
Absolutely, yeah.
But there we are. So anyway, that's the legal position in a nutshell. These are important fundamental rights, and the courts see them in that way, and increasingly see them in that way.
Yeah.
Which brings us on to what we actually do when we get a DSAR.
Yeah.
And at this point, I'm going to pass over to our DSAR ninja, Maria, who will talk us through where we are.
Yes, thank you, Matthew. So let's talk about how to handle DSARs well. And we've put without tears there because I'm sure many of you can relate. And when you see a subject access request, it makes you want to almost pull your hair out. But the first thing I guess to say is structure is everything. And if you wait until you've got multiple DSARs that are piling up on your desk or flooding your inbox, then you're already behind if that's the first point at which you start to think about how to proceed. So what does good structure look like? We've put on the slide here the first point being your written record of processing activities, or your ROPA. Hopefully most of you and your organisations have one in place, but essentially your ROPA is your key. It tells you where your data is held, where it lives, where it's stored, what systems process it, how long data is retained for, and who it's shared with. So when you do receive a DSAR, we'd always recommend heading to your ROPA to see where you need to start looking for the data. What can we say about ROPAs?
What we can say is, well, they're an obligation under GDPR. Most organisations should have that record in place already. So so that's a really good place to be able to start.
Yeah. Moving on to transparency notices or privacy information notices. If you've got a clear policy that tells people what you are doing with their data, how it's collected, how it's used, when you're responding to their subject access request, it can make your life so much easier. And for the individual who's made the request, there shouldn't be any nasty surprises because they should already know what you're doing with their data. Third point is probably one of the most important ones, but you must have a clear understanding of what constitutes personal data. We see far too often people either over-disclosing data or under-disclosing data because they're not sure what actually falls within the definition. So it's really important that you, A, train your staff how to recognise a DSAR, and B, how to recognise what actually constitutes personal data. It's a really, really invaluable tool.
We'll be looking at that in a minute, won't we?
Yes.
Some of the issues around what is personal data.
Yeah, and not every document will contain data that's relevant, but that doesn't mean that just because one document doesn't contain anything that constitutes personal data, that you can then look at other documents and think they're also outside of scope. DSAR policy or playbook. We've spoken about policies, but having a policy on how to handle DSARs internally is really, really key. The policy should set out who's responsible for handling DSARs, whether you handle them internally or you outsource them, deadlines, how to diarise deadlines, who's going to search for what data, because as we'll come on to talk about, data is stored everywhere, particularly in the sort of hybrid world that we're now working in. So your policy should outline if you need to verify somebody's identity, how that's going to take place, how exemptions are going to be handled and applied, and how you document your decision making, really. So having a consistent, clear process is really key, and it can make handling DSARs a lot more efficient.
I think we'd also suggest in that playbook you put the templates for emails you're going to send out to managers who are going to hold data, with an explanation of what needs to happen when, because of course most operational managers will not be putting this top of their list.
Nope.
So it's important that there is a process of communication, and that's properly being established, so they know what to check, how to check it, and by when they've got to provide whatever they've got to provide.
Absolutely, because a lot of the time people don't understand the urgency and the deadlines that are imposed on you to comply with DSARs, and we'll come on to talk about deadlines in a moment. Implementing a triage process for requests. Not all DSARs are the same. They may look the same because they follow a similar format. But like we said, some can be made in the context of a workplace dispute. Other requests can come from customers who want CCTV footage if they visited your branch or your place of work. So each DSAR needs to be carefully thought through, and you must apply a like a dedicated approach, and some may require different resource allocation as well. So it's something to think about.
And I think also there it's a case of being able to spot what is quite a simple informal DSAR. We were talking about this earlier, weren't we? Because I had a client contact me, they'd had a redundancy exercise, and an employee had come to them and just said, I haven't got, and referred to two documents, could you send them to me, please? One of them was a letter inviting them to a consultation meeting, and the other was a note of a meeting. And effectively, the first of those documents was definitely their personal data. So effectively, they were entitled to it under the GDPR. That was a DSAR.
And those are the kind of requests we like to see.
that was a very simple one, but from a triage perspective, very easy to do.
Yeah, absolutely.
So yes, but you're absolutely right. Yeah. You've not all DSARs are made the same.
No. And finally, oversight and escalation. If you're not sure how to apply redactions or what exemptions may apply, which might mean that you don't have to disclose certain documents, do you have a process in place or a dedicated person that oversees that process? That could be someone internally or externally, but they must be confident when they're making those decisions. 9 times out of 10, we see responses being sent out and the individual come back and make a complaint about how their DSAR has been handled. So you should document or have a clear path to escalate difficult issues to, or somebody to handle that for you. And you must document your decision-making process as well, because it can come to your rescue, can't it? It
can, and also we know that one of the key principles of GDPR is principle of accountability, and that means documentation, documentation of decisions taken. And it can also help actually when you're responding to the next DSAR or the one after that. If you can see what you've done in the past, then it speeds up the whole process. So getting that audit trail in place is really important.
So I think our key message here is that if you haven't reviewed your internal DSAR process for a while, probably since the introduction of GDPR, now is the time to do so. It's better to be prepared and have a clear process in place rather than wait for the worst case scenario. And by that point, you may be drowning in a handful of DSARs and they've all got similar deadlines. So make sure you're reviewing your internal processes.
So there's a question there. Must the organisation have a named point of contact who will receive DSAR and same for who will handle the DSAR end to end? In terms of named point of contact, in the privacy information notice, yes, there should be someone who is referred to. That will be your DPO if you have a DPO. But if you don't have a DPO, then yes, having someone who is that point of contact for access rights is important to do. You don't need to make that the same person who will handle the DSAR end to end. That can be someone different. But certainly having that initial point of contact is really important.
So we'll move on to talk about stopping the clock now. So the default DSAR response time frame is 1 month, but if the request is complex, then you can extend this deadline by a further 2 months. So essentially you'll have 3 months in which to comply with the request. You need to notify the individual within the first month, explaining why you're extending the deadline. And that sounds pretty simple. But it's not. So stopping the clock shouldn't be applied as a blanket approach. And far too often we see organisations applying an extension automatically to all DSARs because they have such a huge backlog. So by no means does stopping the clock mean that you can extend the deadline just to buy yourself more time. So the basic rule is that all DSARs must be complied with without undue delay and at the very least within 1 month. So there are ways that you can stop the clock legitimately. The first is verifying the person's identity, and I won't spend too much time talking about this because essentially you have to be confident in knowing who the person is that's made the request. if somebody emails you from their work email address and they are either a former employee or an existing employee, you can quite confidently say, I know who this person is, and their request is legitimate. So you won't need necessarily in that situation to ask them to verify their identity. If the request has come through from somebody's personal email address and it's a very random email address and you're not quite sure who that person is, then yeah, in that situation, it's reasonable to ask for ID in order for you to be able to verify that person's identity. So the timescale for responding to a DSAR doesn't actually begin until you've received the information that you've requested, but you have to be reasonable when asking for that. So you can't just assume that or think, I don't have time to deal with this, I'm going to ask them to verify their ID. Second, clarifying the scope of the request, and this is really important because it can sometimes mean the difference between spending hundreds of hours complying with a DSAR or 10 or 20 hours. So most requests that we see will say something like, I want all of the personal data that you hold about me, mainly because people want to cause a nuisance. And that is certainly not helpful to you or your internal teams that deal with DSARs. So when can you ask for more information? Well, in situations like that, you could go back and ask the individual if they're referring to any particular timeframes. In what context are they asking for the information? So usually in workplace disputes, people are interested in memos or documents where they feel like information about them is held. So it could be to do with a disciplinary process, dismissal, letters, or internal correspondence that's been sent about the individual in that process. So you can ask the individual if they're concerned about communications between specific individuals, but you can't make them do your job for you. If a person comes back and says to you, I'm not clarifying the scope of my request, this is, I've asked for everything that I want, then you just have to almost get on and deal with it, don't you?
Yeah, absolutely. I think it's although that can turn a straightforward request into a complex
one, yeah.
Request, can't it? So I think what do we see here? We see over-reliance upon organisations saying that a SAR is complex.
Yeah.
And that tends to get quite short shrift from the ICO if they ever look at it. Many organisations, I think, will say a request is complex because of their own lack of resources or disorganisation.
Yeah.
Again, which doesn't particularly wash. When we look at verifying identity or clarifying the scope, one of the things I think we see sometimes is that an organisation will say, well, we need to, and absolutely right, we need to either do one or both of those, but then they do absolutely nothing. whilst waiting for the individual to come back. And actually that's added time you've given yourself to respond to a DSAR. So if you're asking them to verify identity, if you're asking them to clarify what they want, in the meantime, at least get on and do what you can to start the process. Because otherwise it's valuable time lost.
Yeah, and locating information that's easy, such as payroll information or data that forms some part of somebody's HR file, that's sort of the data that's easier to locate, and you shouldn't really have an excuse for extending the deadline just because you can't find that information. So our message here really is that applying the extension is not an excuse for poor planning, and saying we're busy or we just haven't got round to it won't cut it with the ICO. So you are expected to have meaningful processes in place to deal with DSARs effectively. So and they shouldn't be used as delay tactics, because individuals will pick up on that and argue that you are deliberately delaying how and when you respond to their DSAR.
One of the things I think strategically, which we will often do because of the fact that we know a DSAR is going to take a while, is is actually try and get that dialogue going with the individual quite early on to say, okay, here's all the stuff we can find for now. We know there is a bit more to come, so we will be continuing with our search. But getting that dialogue going rather than seeing it as a sort of one hit can be quite useful as well, can't it? If you know that there are complexities around it.
And you're managing expectations from the get-go, aren't you? Rather than sending what you've got on the day of the deadline and then saying to the individual, but we haven't found X, Y, and Z yet, so that will follow.
Yeah.
And at least then there are no nasty surprises if you've communicated that prior.
Yeah. Some individuals are more reasonable than others, as you can imagine, with that kind of approach, but it does tend to work as an approach.
Yeah. So identifying personal data, we're sort of getting into the more technical side of things, and we've spoken before about what actually constitutes personal data. It's a broad definition, but it doesn't entitle an individual to absolutely everything. We're talking about information that relates to an individual, and the key word here being relates. So it has to relate to them in a relevant way for it to be considered personal data. And we saw that in the Ashley case, didn't we, where HMRC misapplied the definition of personal data. So Mike Ashley requested information relating to, was it information about his properties, tax information?
Essentially, yeah. I think there was a dispute over how much tax he needed to pay, and it depended upon the valuations of these properties which HMRC had carried out. HMRC refused to disclose the valuations because they said they weren't his personal data, because they were related only to those properties, those addresses. And he said it was his personal data, and that's where the court agreed.
Yeah.
They said it related to him, something which was obviously extremely important to him, which is his net worth.
Yeah.
And therefore, those valuations were personal data. It's very wide.
Yeah, yeah. So that means that if you're talking about a colleague's performance via email, which happens a lot, doesn't it? Then that email is likely to constitute that individual's personal data. Incidental data is something that we advise on very regularly, isn't it? Some important things to remember about incidental data is that much of the data that you're likely to hold about somebody may refer to them by name, but will not necessarily be their personal data, which is why we refer to it as incidental data. So common examples is if you've got meeting minutes where an individual is referred to as having attended the meeting, or an individual has been CC'd into a round robin email along with everybody else about a workplace social. That's incidental data. It won't necessarily contain any relevant personal data. But as you can imagine, I'm sure, depending on how long the individual's worked there, you're probably going to end up with thousands of hits. But yeah, we often advise clients who are concerned about what they have to disclose if you do get lots of hits, because there are so many emails out there that will refer to the requester by name or contain their email address.
We've got a question. If in documents you have used the initials, i.e. JB rather than Joe Blogs, would this need to be added into the DSAR? Yes, it would, because that's still something by which they are identified, and therefore it's their personal data. And again, on the back of Ashley, even if you had nothing in that email which identified them by name, but it still related to them in some way, it would still be their personal data. So we'll talk a bit about this in terms of searches and what you're searching for in a minute.
Yeah. Opinions, they're a talking point, because opinions about individuals do count as personal data, because the individual can be identified from that data. So if you've got emails or notes, documents that say Matthew performed well in the meeting, or Matthew seems distracted, or something along those lines, and that would be personal data relating to you. In the same way as emails saying, oh, I think we should promote Joe, or I'm concerned about somebody's attendance, that also constitutes personal data.
This is an interesting question. We normally ask the employee if they can confirm the name they wish for us to search. If they come back with just their full name rather than initials, would we still need to give initials? Yes, my view is that you as the data controller within the organisation are going to know the kinds of ways in which you will refer to employees, and simply because they come back and say, my name's Joe Blogs, and search against that, but they don't say search against JB or JBlogs or JCB or whatever else you may have used, that's not going to be sufficient, unless they're only looking for something very, very specific, which would only be in their name. But on the whole, you know, we're the ones who should be defining what search terms we're searching against, but I know Maria's going to talk about that in a minute.
Where else can you identify?
Nicknames, same applies. Yeah, absolutely same applies. If they are routinely referred to as Blogsy, then you will be searching against Blogsy.
And if you don't, then you run the risk of potentially missing out data from disclosure. But yeah, personal data is everywhere. Emails, chat messages, Teams messages, even access logs. If you've got a log that shows when your staff log in, log out, biometric data, etc., that all constitutes personal data. Drafts is another funny one that we get asked about. What about draft documents? So the ICO is clear that draft documents do constitute personal data. And so you should look to include drafts within disclosure. Metadata, again, sometimes that can include personal data if you can identify someone from it. But the biggest one is that we get asked about is usually mixed data and the rights of third parties. So I think there's a common misconception among individuals that they are entitled to everything, but that's not the case. Individuals are not entitled to receive data that is not theirs or that contains information relating to other people. That doesn't mean that you can exclude the entire document from disclosure if you can reasonably disclose it, i.e. you've got the third party consent, or you can reasonably redact the document in a way that means that the context behind it is still clear. We've got some more questions coming through.
Someone has asked for information on decisions taken regarding termination of probation. However, everything has been done verbally with nothing written down. What do you suggest is done? There's nothing to disclose if it's all verbal. There is no personal data for you to disclose, so you don't need to regurgitate that into a written form for the purposes of the request.
No. So ICO guidance requires us to make reasonable efforts to find and retrieve the requested information. What are your views on interpreting reasonable? For example, if the initials for Ian Smith are IS, that would be a lot of emails to review. Yeah, and we see this all the time where IT companies come back and say, well, you've got thousands and thousands of hits. I guess it's about the way in which you use your search terms. So we would always recommend putting search terms into inverted commas. If you've got initials such as IS, then you capitalize them so it gets rid of any words that contain the letters IS in lowercase.
I think we're going to be looking at that a bit more in a minute, aren't we, in terms of search hits, etc. But I think you're absolutely right. The obligation is to conduct a reasonable and proportionate search, and that's now going to be enshrined in legislation because it's in the Data Use and Access Act, whereas before it's only been in the ICO guidance. We're expecting quite a lot of litigation over what is a reasonable and proportionate search, but we'll come back to that in a minute. We have problems where they believe data exists
that
doesn't, and they won't accept that it goes back and forth with. Yeah, I think it's a good point where many employees will, or many subjects will say, well, you must have something on that, and we say, we haven't. You know, and I think what can you do about that? Because it's very difficult to prove a negative. I think it's one of the reasons why we would suggest with any kind of serious DSAR, you're trying to get that dialogue with the individual, with the requester, so that they can get some, you know, you can earn their trust and actually say, when we are disclosing, we are disclosing. And if we're not disclosing, it's either because we don't have to or it doesn't exist. Where we have to be really careful with that is where litigation then ensues afterwards. Say you've got an employee who then goes to the employment tribunal, because of course you're going to have other obligations of disclosure later down the line. And it is very, very common for an employee or former employee to say, you didn't give me that on your DSAR, but you're giving it to me now. Why?
Yeah.
Very common indeed. So we have to be absolutely sure if something doesn't exist, that it doesn't exist, because when we come to apply these duties of disclosure in the courts, we can end up in some really difficult situations.
Yeah, and that's why it's so important to have your paper trail, isn't it? So you can legitimately say to the individual, these are the platforms we searched, these are the search terms we used, this is what was returned, and this is what constitutes your personal data.
Exactly.
So I'll move on to the next slide, identifying where your data lives. And again, this comes back to your ROPA. So if you've accurately documented your processing activities, then it shouldn't be too difficult to ascertain where your data lives. So common systems, HR information systems, if you've got a HR platform, or if you've stored data in OneDrive, information will be contained there. Outlook, Teams and Slack, again, very commonly used platforms. So don't forget to search those. Line manager notes and notebooks. Again, we get asked this a lot about handwritten notes and what we do about those. I sometimes find that the notes that are handwritten aren't legible.
Who could you be thinking of there?
I'm not mentioning any names. We've spoken about mobile phones, text messages and WhatsApp messages. Again, it's such a grey area and can be a real tricky process to navigate, particularly because often we find that IT teams will come back and say it's actually a lot more difficult to extract data from Teams, and particularly WhatsApp if the right infrastructures aren't in place, and if it means you're asking for data that's potentially stored on personal devices. So it's really tricky. And what can we say about WhatsApp?
Well, I think where we get to is it comes back to this proportionality thing, which I think overshadows everything when we're looking at sources of data and how we get this data out of systems. There are some systems where it is just too difficult to extract the data.
Yeah.
So mobile phones is often an issue. Trying to get text messages out of mobile phones can be really difficult. The other one we see a lot is where we've got financial services companies who use WebEx, for example, which can be really difficult to do that. And I know there's been some problems with Zoom as well. So effectively, there are systems where the technical steps to actually get the data out can be too difficult. And there we are going back and saying, well, there are some issues around proportionality of that data. But it only works if you are actually able to say, here are all our sources, here are all our repositories of data, and here's what we've been able to do. And to do anything more than that would not be proportionate. You've got to sort of take a very wide approach initially, and then I think narrow it down. There's a contact there. What do you suggest where some managers contact their employees when they are on it through WhatsApp or messages as they are not on Teams? Long-term sick. Well, again, I think if you're looking at WhatsApp for contacting individuals, then you're starting to bring WhatsApp into the corporate
workplace,
portfolio, and that is meaning that it is more likely to be something which you could be required to search. If I had my way, there would be a law that says do not use WhatsApp for work purposes, and that would make everyone's lives a lot easier. Or there will be a button on WhatsApp you could do it which said, well, this is work, therefore it's not going to be sent, because WhatsApp is a nightmare. And my advice is really, really do not use it. Issue all of your employees with a device that they can use in a mobile way, and put Slack, Teams, whatever is the company standard on that, and do not let your managers use anything else. That is the way to do it. Now, that's counsel of perfection, but WhatsApp is a nightmare. Okay, if there's one thing you take away from today, it's what's happening.
And I guess just another point on Teams messages. A lot of contacts that we have will employ retention policies within Teams. So messages will disappear after, say, 30 days, which can make life easier. However, it doesn't stop the individual from saying, well, you need to look at your archived systems or your deleted systems. And the same applies for legacy systems. So if you've had platforms that you've used in the past that are now no longer being used, but data is still held on them, the ICO to a certain degree will expect that you also search deleted items. But again, that doesn't mean that you have to turn over every stone if it is genuinely disproportionate to the request.
Yeah. If your IT company is coming back to you and saying it's going to cost several thousands of pounds to get that data back and live, then it's almost certainly going to be a case of being disproportionate to access it. But each decision like that needs to be made on its own merits, and each one needs to be documented.
Yeah. I'll quickly talk about AI tools, because we're seeing a lot of businesses use ChatGPT or Copilot to record meetings, produce the written notes and follow-up steps, and 9 times out of 10 those notes will refer to an individual or whoever it is that you've been talking about. And we get asked all the time, do I have to disclose those because it's AI? Those meeting minutes will probably say something either positive or not so positive about the individual, but remember what the definition of personal data, if it relates to someone, either indirectly or directly, constitute personal data.
So you've got to disclose it.
Yeah.
Yeah.
I'll move on because I'm conscious of the time, but how do we deal with data overload? So we've identified the source of the data and we're potentially looking at thousands and thousands of hits. So how do we make that manageable? Well, have a think about how you apply search terms. If the individual has been helpful and has provided you with the search terms they want you to use, and again, you'll probably have to go back and look at the request itself to identify what they're asking for. It can help in terms of getting the balance right. So if you search too broadly, you'll drown in irrelevant material. If you search too narrowly, you may run the risk of missing things that are in fact within scope of the DSAR. And that can create risks and challenges, because the individual will come back and say, well, I know for a fact that X document exists and you haven't disclosed it to me, which leads me to believe that you haven't complied with my DSAR in the way in which you should. So have a think about what you're telling your IT teams to do. What search criteria are they using? So be very specific about the time periods that you want them to search against. The systems to include, so if it includes Outlook, OneDrive, SharePoint, Teams, etc. What systems are in scope? And again, what categories of information are you looking for? So make sure that you document these decisions from an early stage, because as we've said, it will only help you further down the line.
And I think also here it's worth remembering about proportionality. We often have a client who will come to us and say, I've done the searches and I've got 28,000 hits. Help, what do I do now?
Yeah.
So you say, okay, we'll take a deep breath. First of all, where are these hits coming from? What kind of systems? And they'll say 13,000 are coming through Outlook and 10,000 of those are diary entries. Well, we're not going to look for the needle in the haystack of the diary entries to find the one that is relevant.
Yeah.
That would be disproportionate. So we say, okay, we're going to disregard all those 10,000 searches. We're not going to look at them further. And that's the kind of process which you need to do. You need to apply, because that's where the proportionality comes.
Yeah,
comes
absolutely.
Through, isn't it?
And if there are other key terms that you can use, so if you know that the employee's made the request following a workplace dispute, such as a grievance or dismissal, you could potentially use those words, grievance and dismissal, in the same search category, because that will weed out information that is relevant.
And I think it's fair to say, after the several hundreds of DSARs which we've had, we've got quite good at looking at where that methodology comes in.
Yeah.
And actually where you can say, okay, well, we're gonna put that to one side because we don't need to look at that. We're going to focus on this, and then to give you a defensible position.
Yeah, absolutely. And again, we've mentioned it again, document your methodology.
Always document your methodology. Yeah.
So scope hits. Well, we've run the searches and we're now looking at the results and how we manage these effectively. So it's no surprise that if you're searching your corporate email systems, that you can expect thousands of emails to come back as search results. So when you're looking at them, as Matthew said, you might be able to see duplicates of documents or thousands of meeting invites. So deduplication is absolutely essential. So if the same email appears in 3 different mailboxes, you only need to review and disclose one of these. So a shameless plug here, we've implemented an e-discovery software that helps with the deduplication process, and that really cuts down the number of hours involved in manually having to review documents. So if you think about doing this in-house, please think really carefully about what providers you are using. There are some really dodgy ones out there. And particularly if you do use an external provider, think about whether or not they're using AI to assist with automating certain workflows. We don't have time to go into AI and automated decision making in this session, but I know it's something that we get asked about quite often. So yeah, in terms of the deduplication process, just think carefully about how you're doing that.
There is a tendency, I think, now for people when they hit to a DSAR to go straight online and look at what software can help them. But they're forgetting that often, particularly when there's AI, there is a need for a separate impact assessment, separate information notices, etc., before you start using those tools. So using those tools safely is actually very difficult to do.
Yeah. And don't think about implementing it with 2 weeks to go, because that will only slow you down. We've spoken about prioritising high value, high relevance resources, and again, refining the keywords that you use can help reduce time dramatically. So we won't keep banging on about it, but keep a clear audit record of all your decisions. Review and redaction process. This is my favourite bit of a DSAR, because I get to read all of the documents and decide what's in scope and what's not, and what can be redacted. So there are several categories of information that you can redact or withhold. What do we deal with most? Legally privileged documents, advising clients what constitutes legally privileged, and when you can withhold that from disclosure. Confidential information. Again, this might be commercially sensitive information, information that contains commercial strategies. The most important thing to remember about this particular point is that confidentiality can't be used as a blanket excuse not to disclose something. So you need to carry out an assessment as to whether you think the document can be disclosed if it's redacted. And that same sort of methodology applies to third-party data. You can't just withhold something simply because it refers to another individual's name. If that can easily be redacted, then there's a level of expectation that you should do so. And third-party data and mixed data challenges, they're kind of intertwined with each other, aren't they?
Yeah, they are. And I think we see some overzealous redaction around names. So you can't, normally if there's a communication from a manager or something, you can't really redact their name because the individual will know that they are the person taking decisions about them. Mm-hmm. It's really only where there's sensitive information about another employee or similar where you should be redacting that third-party data, but many people are far too heavily redacting, in our view.
They are, and again, we see individuals come back and say, why have you redacted all of this information? Yeah. I can't understand the context behind the document, and that's where you can land yourself in some hot water. So again, keeping a record of why you've redacted something, redaction quality control, is really important because it can help you in terms of your response to the individual.
So there's a quick question. When protecting the rights of other individuals, can rely on their expectation of confidentiality, e.g. witness statements about behaviours of the data subject? Yeah, absolutely. That's the kind of thing where it's perfectly appropriate to apply redaction, to take out individuals who may be vulnerable as a result of the fact that their data are going to be disclosed. But that reduction in that circumstance shouldn't then become a general redaction of anyone's name. It should be kept to where there is information about them which is properly confidential or otherwise sensitive.
Yeah. One of the issues with redaction and quality control is that it's very easy to miss things. So it's very easy to forget to blank out somebody's name if you've been staring at a load of documents for many hours. So quality control is essential.
And again, I think now we have special software which allows for sort of a quick redaction.
Yeah.
And it works. I'm conscious of the time, so we'll rattle through the final few.
Pitfalls. I mean, we've talked about the risk of under disclosing and over disclosing, but making sure that you are being consistent when you're responding to DSARs. Different parts of your organisation may handle requests differently, particularly if you've got multiple people dealing with requests. You may respond to one DSAR in one way, and then 6 months later you may respond to another DSAR in a completely different way. So it's really essential that you do apply a consistent approach. And again, poor documentation of decision making is another pitfall that we've seen. 9 times out of 10, you just want to get the DSAR off your desk, and you think actually documenting what I've done is going to take me even longer, and I'm just not going to bother. But the ICO will be increasingly unsympathetic to you saying, well, we tried our best, without being able to point towards your process. So it's a really key thing to think about. And again, applying extensions without evidence. If you're waiting until the 11th hour to inform the individual that you're extending the deadline, you're only going to end up in I'd say dispute is probably a bit too strong a word, but the individual is not going to be happy about it.
It gives rise to more and more complaints and more mistrust of the response you provide. We particularly see that one in tribunals, where there may be a dispute going on at the same time as the DSAR is being dealt with, and the delays are given a sort of seen as being bad motive from the individual, and that's where we tend to get victimisation claims connected to it. So be particularly careful of that.
And have a think about where your employees or your staff are keeping data. Do you know where data is being stored? Are people saving personal spreadsheets in their desktop? What about your archived email accounts? So that's sort of a data governance issue as much as a DSAR issue. And that one, I think, has become even more live now. We've got ChatGPT, etc. If you have managers who are routinely feeding through data to produce a letter to a member of staff, then all of a sudden ChatGPT is one of the data sets which you've got to be searching. Yeah. So if you are concerned about your DSAR process or even data governance issues, then please do come and talk to us, because we live and breathe it, don't we? We do. We love it. So, and on that point, we're just going to finish up. So hopefully you found that useful. Many organisations deal with DSARs in-house. We are here if you need to outsource. We're particularly here where there is an obvious legal risk, and of course what we have as an advantage there is legal privilege. Not only can we assess whether documents are legally privileged, but actually the process of assessment itself and our communications with you around that are legally privileged, so that helps. As I said, we've been doing these things for many years indeed, so we built up some good protocols for how to cope with them. And that's what we provide. So we're here to do so. In particular, just to mention the technology, we've DPIA'd all our technology, impact assessed it, and that allows us to really get ahead in terms of how we do these things in a cost-effective manner. And we recognise how stressful DSARs can be and time-consuming. A lot of the time, our clients that we work for just don't have the internal resources to be able to deal with DSARs effectively, and that's where you can end up having such a big backlog of requests that need dealing with. And And yeah, as we said, you just end up with a whole host of complaints, don't you, if they're not being dealt with efficiently.
But I think also if you want to do them in-house, we can help you with that structure,
For sure.
and actually putting into place the roadmap and the playbook, etc.
Yeah.
So where are we? Well, DSARs are not going anywhere, which is sort of signified by how many of you have been with us today. And as we said at the beginning, the legal risk is increasing. It's not decreasing. I think the Data Use and Access Act and the obligation to handle complaints is really going to have a very significant effect on that as well. At a time when data and managing data are becoming much more complex by the number of channels available and the amount of data being processed by us all. But I think that last point is a key one. Process and technology are your friends. Yeah. Making sure that you've thought about how you're going to deal with DSARs in advance, making sure that you've got a structure in place to do so, and making sure that you are using your tech in the right way are absolutely key to making these things as easy as possible to deal with internally. And if you can't deal with them internally, then do give us a call.
Absolutely, yeah.
Thanks very much for listening. We are out of time, but we are very happy to take questions by email if you wish afterwards, and we'll get back to you on any points that you have. Thanks very much for sticking with us.
Lovely. Thanks very much, everyone.